Hello and welcome everybody. My name is Christian Tams. I'm Professor of International Law at the University of Glasgow. Welcome to the second Google Hangout for our MOOC, our Glasgow MOOC on Right versus Might in International Relations. It's great to be doing this. It's great to be having an opportunity to engage with you after having read comments and having read questions. I think this is really an exciting experiment. I think it's a good course by MOOC standards. I mean, there's a lot of engagement, a lot of comments from different people. Of course, some are more active than others. But I think reading through the discussions, I think there's serious engagement and informed debate. So precisely what we all had been hoping for. So it's great to be sort of part of this experiment. More specifically, I'm glad that a few people in this second week have commented on our method of picking specific disputes, fairly high-profile disputes, and addressing them through case studies. I think that was a bit of an experiment. I think it's a useful way of getting sort of the law away from the stale, formal language and to show that it matters in real life. And of course, to highlight areas where it might matter more, where we want the law to be complied with and where in reality it isn't fully complied with. Now, this second week, as you will have noticed, and that's clear from the comments, was different from the first week. The issue we've been discussing, or we've asked you to discuss, was not quite as dramatic. It doesn't get more dramatic than drone strikes at this point in time. Guantanamo Bay is also a dramatic dispute in international law, but we were deliberate in focusing your attention away from the treatment of prisoners in Guantanamo Bay and to the underlying issue, the existence of a treaty that for 110 years has justified or legitimized, possibly not legitimized, but explained the US presence on Cuba. So our focus has been on an age-old, a venerable treaty that perhaps international law should get rid of. And that's the big question for this week. So the underlying point was to get you to think about the sometimes surprising lifespan of international treaties. And why is that important? It's of course important because the Guantanamo Bay Treaty is an important one which we've been discussing over the past decade in particular. But there's I think, a message beyond that. And that's an important message which I would like to use the first 1 or 2 minutes to maybe explain and set out in a bit more detail. And the point is this: if you're thinking about international law and how it functions today, then really it is dominated by treaties. International law has different sources, but treaties dominate. About 60,000 treaties have been registered with the United Nations. If you want to know what states agree to do in international law and what they oblige themselves to do, you have to look at treaties. As some of you picked up in the comments, and I think that's an important point, treaties are on the one hand ubiquitous, they're everywhere, they're dominant, and on the other hand they can be good or bad. Treaties are the way by which the world community agrees on standards to make the world a better place. Think of human rights treaties. It's a treaty that enshrines values. But treaties can also be means, and have traditionally been means, of entrenching inequality, and that's one of these treaties that we're discussing this week. A treaty where we don't that confidently say that this is a treaty for the better. It may have been a treaty that stabilized a situation with which we're not at all comfortable. So the insight that treaties can be a force for good and a force for bad, but that they're dominant in current international law, that's, I think, the most fundamental point to take from this week's discussion if you want to learn about international law generally. Now, of course, our focus is not on treaties in the abstract. As I said at the start, this is a course that is based on specific disputes. So we weren't going to make you read 60,000 treaties. One specific treaty or two specific treaties, the lease agreements about Guantanamo, they matter. But again, before I get to speak to them in a minute and before I get to answer your questions on them, let me point out that one of the exercises, of course, also clearly brought out that Guantanamo Bay is not the only military base. Quite a number of your countries that where you come from have signed military lease or naval base agreements. And that doesn't really matter whether you're sort of from the US, from Canada, from France, from Germany, from Africa, from Latin America, from Asia. Most of the countries of the world, in one way or the other, are involved in arrangements about military bases. So at some level, the Guantanamo Bay naval base is just a normal military base on foreign territory. That's what states have done for a long time, sign agreements whereby one state lets part of its territory be used by another state for certain purposes. Now, the Guantanamo Bay Treaty is special, of course. Not all military leases have been in existence for 110 years. And hardly any military lease has survived the sort of dramatic shifts in American-Cuban relations that we've seen over the past 100 years and that you've read about in the course of this week. So I think we picked this treaty for a reason. It's a special one. It remains in place after 110 years, and now I'm getting closer to the specific treaty of this week, even though, and that's a point that some of you raised, even though it may have been breached. Many of you have commented on the US and how they would breach the naval base agreement. I'll come back to some specific aspects of that in a minute. But I think more fundamentally, or at the level of general points, I think it's important to note that for contracts in normal domestic law or for treaties in international law, we need to distinguish two levels of inquiry. One is whether a treaty has been breached, and the other is whether a treaty remains in force. So it may be that something that the US does on Guantanamo breaches the treaty. But the breach of a treaty doesn't bring about its termination automatically. Just as if you have under domestic law or back home an arrangement that somebody, a tenant, rents an apartment from a landlord, if the tenant misbehaves once, it doesn't mean that the tenancy automatically comes to an end. It may be a reason for the tenant to be kicked out under a certain process, but there's no automatic link between breaching a treaty or a contract and the validity or the continued existence of the treaty. So I think that's an important point to bear in mind, or maybe sort of two important points to bear in mind. States regularly conclude military base agreements, and when we're looking at treaties, we need to distinguish between two things. One is, have they been breached? And second, do they continue to be in existence? Now, all that by way of sort of, if you want, introduction to this week's topic. I'll now go about answering some of the questions that you sent, and I would encourage you to continue sending questions. We may not have time to cover all of them, but if I don't have time to cover them in the next 20 minutes, then we'll certainly make sure that they will be covered by our brilliant student mentors, James, Pia, or Asini, and they will deal with those matters as the course evolves. But do send in questions. I mean, this is the essence of this course. It's meant to be interactive, and if you're sending them in during the Google Hangout, you have at least a chance that they're responded to immediately and in a live chat setting. So the first question that I've sort of picked from the questions that were sent in was by Lara Engel. So Lara Engel commented, sort of is one of the active participants on this course, and that's brilliant. And Lara, you asked whether treaties that legitimize inequality should be tolerated, whether the law of treaties should tolerate this sort of function of treaties. And of course, that is precisely the $1 million question of this Google Hangout and of this week's session of our Glasgow MOOC on Right versus Might in International Relations. I mean, it's precisely about identifying the reasons that lead international law to be fairly tolerant of certain types of treaties, even where we might say, well, look, they look dodgy. It's not really fair. Now, there's two levels of answering your question. So, Lara, the first level would be to look at the law of treaties, and many of you have made references to the Vienna Convention on the Law of Treaties. That is the treaty on treaties, the treaty that governs international arrangements. Incidentally, I'll make a point in passing. The Vienna Convention was agreed only in 1969, but it's considered to be generally a reflection of generally agreed principles of treaty law. So for ease of reference, we have simply assumed that it would apply to the Guantanamo lease agreements, with one exception that I'll speak to in a minute. And I think generally we would say, most international lawyers would treat the Vienna Convention provisions almost as a Bible canonical relevance They deal with questions of treaty law. Now, Lara, the first answer to your question then is that the Vienna Convention tries to strike a balance and tries to find rules addressing precisely that conflict. Should treaties be tolerated where they entrench inequality? And as you've seen from the reading, it goes quite some way in doing that. It goes quite some way in doing that. It, in principle, adopts the view that treaties are binding and are valid. The lawyers would speak of a principle of party autonomy. What the parties to a treaty agree to write into a treaty is perceived to be an acceptable compromise solution for them. And then the Vienna Convention lists various exceptions, and we've introduced in the readings the main ones. So if force was used initially, then the treaty was not valid. And maybe that's a point to be discussed with respect to the Guantanamo lease agreements. If the treaty is breached, then it may have been valid, but there may be a way for the other side to get out of it. And again, we'll come back to that later on. If the circumstances which obtained when the treaty was concluded have changed dramatically, then it may be way out. So all these reasons exist, and you're encouraged, as those of you who've looked through the course outlined for this week have seen, you're encouraged to make use of those arguments as you deal with the Guantanamo lease agreements. But, I mean, these are exceptions. And as we've made clear in the readings, these are exceptions that are purposefully construed narrowly. Now, why is that? Is international law just blind to values? Well, it's not. Not absolutely. But I think international lawyers drafting rules on treaties were conscious that they couldn't prescribe the outcome of treaties in any general sense. Party autonomy, the idea that treaty parties would be the best judge of what they want to be binding between themselves, was the rule. This rule wasn't without exceptions. I've mentioned 3 of them or 4 of them. But it was the rule, and fundamentally, the drafters that drafted the Vienna Convention on the Law of Treaties were unwilling to go down to the specifics and say these treaties are allowed, those treaties are fine, in a specific and concrete way. There's just too much variety, too many different situations. You can't pretend when you draft general rules of treaty law to be saying specifics and to be outlawing specifics. And there was some discussion, and I think we referred to that in the readings, a proposition that in the law of treaties you should have a rule that says unjust treaties that are just fundamentally unjust, they should be invalid. But again, I mean, we will all nod if we say treaties should not be unjust. But what does it mean in practice? Is the Guantanamo Bay Agreement from 1903, is that an unjust treaty that should be tainted and invalidated? Perceptions change over time. In 1903, maybe this was common. In the 1900s, states concluded all sorts of agreement that nowadays we would find horrendous. Perceptions change over time, sometimes for the better, sometimes for the worse. The idea that a code of treaty law could generally formulate a rule that unjust treaties should be non-binding was just too general. People felt this was open to abuse. States that didn't like treaties anymore could always say, well, this is an unjust treaty and get out. So I think fundamentally, in the end, the drafters of the Vienna Convention decided that no such rule against unjust treaties should be included because it would be too vague a rule. So that is a long first answer, Lara Engel, to your question about treaties and whether they should be, they would legitimize inequality. Under the scheme of the Vienna Convention, that is certainly possible, and that's why treaties can be a force for good and a force for bad. They are not always scrutinized. The Vienna Convention leaves it to the parties to make up their minds about what they want, and only sets outer limits. And you'll be asked to discuss some of the outer limits in relation to this, the Guantanamo lease as the course evolves. A second answer, much more brief, is of course that whether the Guantanamo lease treaty is one that entrenches inequality, which I think, or legitimizes inequality, as I think was your term, is of course a matter of perspective. I mean, some might agree to that, others might not. It's a question on which some people would disagree. It was certainly, was it fundamentally illegitimate in 1903 for one country that had somehow helped procure another country's independence to maintain some sort of naval base? Was that fundamentally illegitimate in 1903? At least I think the least we can say is that you can have different views on that matter. So legitimizing inequality is a term that is full of sort of vague clauses where you can have different views. All right, that is a very long answer to a fundamental question that was raised. I'll speed up a bit in dealing with 3 or 4 more questions and try to rearrange them so that they would fit in more or less in a coherent order. Now, the second question then is one by Colleen Huckabee. Now, Colin, you raised a question which was in some ways sort of, again, spot on, but followed on from the bigger question raised by Lara. And your question was sort of assumed that if international law is quite in favor of treaty stability, would states really be encouraged to sign up to treaties if it was so difficult to get out of them? And that's a good question, precisely because it allows us to pursue a point that I think maybe needed to be made clearer than I made it in the readings. And that is a point about sort of treaty stability and the general law of treaties. If you want to get out of a treaty, there are many, many ways of ensuring that you maintain that right. Many, many treaties have withdrawal clauses. You can just terminate them almost at will, typically with a 6 months notice, so that other states, parties can deal with the situation. For most, or for many, many multilateral treaties, you can withdraw. But the treaties themselves say so. So if you sign up to a human rights treaty, many of them have withdrawal clauses. When the United States withdrew from certain sort of disarmament treaties, they could invoke certain withdrawal clauses. Sometimes you need to explain why you're opting out or why you're withdrawing. Sometimes you can do so without giving reasons. But many, many treaties, especially multilateral treaties, allow for that option. There is typically a way out. And why is there a way out? There is a way out because the particular treaty in question says so. Now, remember, we were talking about a treaty that doesn't have such a clause, that doesn't have such an exit clause. So Cuba cannot simply point to, let's say, Article X of the Guantanamo lease and say, well, look, this lease was only concluded for 30 years, or after 30 years we could opt out at any point. This lease is a lease that was agreed for an indefinite period of time, until the parties agreed that it was no longer needed. And that is very peculiar. It's special. It may be a factor that we build in when we discuss whether this is a legitimate or not a legitimate treaty. The idea that you would be bound in eternity almost. But it's a particular feature of this Guantanamo lease treaty. So to come back to your question, the answer would be normally the stability of treaty relations under the Vienna Convention isn't such a discouraging factor, because when states want to be able to get out of treaties, they write an exit clause into the treaty, and then they can always make use of that exit clause. Okay, third question. Alice Mill got us closer to the application of this Guantanamo lease agreement, and she asked whether torture was legal or legitimate under the terms of the Guantanamo lease treaty, which allow the United States to use Guantanamo as a naval base. So would the United States' right to use Guantanamo Bay as a naval base encompass the treatment or mistreatment of terror suspects? And in some ways that is, again, a $1 million question, a crucial question that's being raised. In other ways, there's also a question on which I shouldn't be saying too much, because that's precisely what we want you to argue about as you engage with the task of preparing memorandum for the Cuban government or for the United States government. So we would want you to engage with precisely that point. Has the Guantanamo lease treaty been breached, and would this give Cuba a way out? But let me make a couple of points, and I think I'll mainly without giving away too much, I hope. I think the question precisely directs us into a key area, and that is the area, also the need to read the treaty specifically. The treaty gives the United States quite far-reaching competencies, but it is specific in that Guantanamo must not be used for all sorts of purposes, but as a naval base. Now, you can disaggregate the question what that means. A naval base is obviously used for ships and shipping and sort of marine installations, maritime installations. Would the running of a pub on a naval base be covered? Is that used as a naval base? Well, you need to sort of have common sense. Naval bases tend to have pubs, so that's presumably not illegal. Go one step further. Would the use of the detention facilities be excluded on a naval base? Remember, the treaty says you can use it as a naval base. A detention facility as such, I don't know, it's part of very many military installations. Typically, a detention facilities for disciplinary action against members of the military, but maybe not exclusively. So again, that's probably not as such excluded. Now we're getting to the point and closer to your question and getting to the point where I will refuse to answer in order not to sort of not to undermine the discussion that you will have. Of course, then you get to bigger points. If the main purpose of the base then is to host terror suspects from another side of the world, is that still used as a naval base? If the matter gets completely removed from anything naval as opposed to sort of military and security, is that still used as a naval base? And of course then, the question you specifically raise, if something criminal is happening, would that still be condoned under the terms of the treaty? So I think you'll see how I've probably not skillfully, but sort of genuinely tried to avoid your question by disaggregating it. I hope in disaggregating it, I've sort of pointed you towards some arguments that you can advance in dealing with the discussion. Of course, Alice Mill, now that you've raised the question, we would be sort of looking out for your contributions to the task that we're setting you in the final stages of this week's MOOC, namely to draft a memorandum and to discuss whether Cuba could get out of the treaty. Okay, I think we've probably got time for 2 or 3 more questions. One is one that has been discussed quite at, well, not at length, but in, I mean, on frequent occasions in the discussions in writing, and I think it's one that is of general relevance, and I'll simply draw it out. Mary Hawking asked more generally about the impact of revolution on treaties, and that is, as I said at the start, one of the key features of this Guantanamo lease agreement with all its 110 years of life that we're looking to. So in those 110 years, there were momentous developments, but probably from a treaty law point in terms of US-Cuban relations, none was quite as momentous and dramatic as the impact of the Cuban Revolution on the underlying treaty relations between Cuba and the US. Now, it's not a one-off process. It wasn't that, as those of you who studied history and diplomatic history know, it wasn't that from one day to the other everything changed, but it's a fairly identifiable period in the late 1950s, 1960s, early 1960s that Cuban-US or US-Cuban relations changed fundamentally. Now, to what extent does that affect treaties? The formal or the one level of the answer we've given in the readings, not. International lawyers have reached an agreement to treat revolutions and monumental and massive changes of government structures not as a case of state rupture, not as a case of state succession. The state of Cuba, as a purpose for the purpose of international law, was the same in 1955 that it was in 1965. Batista or Castro may be figureheads and leaders and may have decided on massive changes of governmental policy within the state of Cuba, but from an international law point of view, which is quite formal and deliberately formal in this respect, Cuba was the same. And I think that's true for, that's been the position that's been adopted in respect to all massive and major revolutions. And it's not a position that's been popular with the Cubas post-revolution, or Soviet Union 1917, or Iran 1979 after the Islamic Revolution. These states have tended to say, well, look, we have undergone such a dramatic change that the statehood of our state is no longer the same. We cannot be bound by the treaties of the previous regime. But international law has been fairly firm in saying that, well, we need to draw a distinction between the government, which changes in revolutions, and the entity of statehood, or the concept of statehood, the state as such, The legal personality of the state remains the same. So from that perspective, the revolution as such has no impact on the treaty relations. The Cuba of 1963 remained bound by the treaties of the Cuba of 1955. So it was not a question, to use the technical terms that we're introducing in the readings, it was not a question of state succession. It's a question of government change. Now again, why is that? You might say, well, isn't that sort of a formal or formalistic rule? To some extent it is. When all the life changes in a state after a massive upheaval, why should the state still be treated the same? So it's a rule that's open for discussion or open to questioning. But ask yourself, if you question it, whether any other rule could work. Doesn't the international system, with treaties, with rules, depend on continuity of entities? If every revolution, or if revolutions would be treated as absolving the state from treaties previously entered into, where would one stop? Is it only the Cuban Revolution that legitimizes sort of a clean slate, that Cuba starts afresh? Only the Bolshevik Revolution in 1917? Only the Iranian Revolution in 1979? Or a landslide victory of the opposition party in the elections in another state? Where do you draw the line between a landslide change of government with massive impact and a revolution that would allow a state to get out of treaties? I think a rule that would generally say revolutions are changes of statehood would be introducing a lot of uncertainty, precisely because you do not know where to stop. Now, there's a caveat, and that caveat again points us, or points you, towards the discussion that we're encouraging you to have as the MOOC week number 2 comes to an end. And that is, what I've just presented in some ways is the conventional wisdom or the conventional rule, but it's not absolute. And query whether things like a massive revolution or revolutionary change within a government could be relevant as you look at the treaty law concept. And in particular, have a thought or give some thought to the idea whether this flexible concept that treaties can be suspended under narrowly defined circumstances if the circumstances that obtained at the time they were concluded no longer govern. The idea of a fundamental change of circumstance. Query whether you can use arguments about the revolution when applying that treaty law concept. I'm not going to say more, not to spoil the discussion, but simply to say, well, the revolution as such will not have an effect on treaty law, and I think rightly so. There may be ways and means and avenues of bringing or of using arguments related to that point when arguing from within the existing concepts of the law of treaties. Okay, now that takes us almost to the end of this week's Hangout. I will make one brief comment to questions that were raised by 2 of you, and then I'll sort of make a few more sort of comments by way of conclusion. The remaining question that I wanted to address is one that was raised by a few of the learners. I've only noted down 2 names, Michael Hartman and Jeff Green. You both, I think, raised a point that was absolutely crucial as well. You see there's a sort of a pattern to my picking of responses. I'm answering the question that I found super crucial or extremely crucial. And the question that you both, Michael and Jeff, raised goes to the forum. Assume this was a Cuban-US dispute about the validity or continued validity of the Guantanamo Bay lease. The sort of discussion we invite you to have now, more or less, as you complete your second week of the MOOC. Where would that dispute be resolved? Well, I suppose in the MOOC setting between you discussing it. And we do encourage you to take that seriously. It's an engaging debate, and this is sort of precisely sort of an opportunity that you have to apply the law. Now, where else outside a MOOC setting does this discussion take place? And how do we make sure that whoever is in the right legally can get this right position sort of enforced? Many of you mentioned that, or many of you have mentioned sort of in passing that in international law you do not always have access to a court. If Cuba felt it did have a way out, it couldn't simply take the US to court. Or if the US wanted to have a court ruling or a sort of an authoritative ruling that this treaty is still valid, it simply couldn't take, or it couldn't simply take Cuba to court. One point we'll come to discuss later on is that in international law, courts and tribunals have a much more limited jurisdiction. And in this case, this matter couldn't simply be brought before a court. So where is it being discussed? Well, it's discussed diplomatically. The legal perception of the sort that you're going to bring forward in your discussion is brought forward in governmental memoranda. It's brought forward in discussions in the United Nations General Assembly. Pressure is brought to bear on parties that are seen to be violating the law. In this particular case, there have been movements by Cuba, I mean, never really going very far, of sort of mobilizing the General Assembly to request what is called an advisory opinion, a non-binding advisory opinion by the International Court of Justice on the status of Guantanamo Bay. In the end, Cuba decided not to pursue this. Perhaps it is quite happy to be pointing fingers at the United States for still holding part of Cuban territory, a point that is made by Vaughan Lowe in the readings that we've set for you. So there are many, many fora where this matter is being discussed, but there is no, and I think the question points us exactly to that, Jeff and Michael, there's no one court that would be competent to decide this authoritatively. Cuba and the United States could always decide to bring the matter before a court. But at the moment, if the two of them are not in agreement on this, no court would have jurisdiction to address this matter. Now, as I said, this is the underlying theme to that question, and this is why it's an important question, goes to the role of courts in international law, and that's a point to which we'll return. And I think one of the messages of this MOOC is that you will get to see that in international law, it's not always that disputes are litigated before courts. They have a lesser role than they have in many states in which courts have assumed massive influence over the political and legal process and get to decide crucial questions, for better or worse, get to decide crucial questions of the sort of political, of the national political discourse. Okay, this concludes my review of some of the questions. Apologies to those among you whose questions I haven't been able to address. As I said, I mean, do send them in writing, and they will be dealt with in writing, or we will come back to them at a later stage. Let me just sort of conclude by saying that this week, I think possibly sort of emphasizing a point I made at the start, this week was in some way special. After the sort of the drama of the drones, week one, we deliberately wanted you to focus on a historical topic, because that too is international law. Treaty stability, longevity of treaties, the fact that treaties can be in existence for hundreds of years. So it's not all about current relevance. But if you felt this was too historical or too archives focused, then rest assured that from next week onwards we'll be back to the current action. So next week could hardly be more current, the sort of the topic for next week's discussion. Some of you may have looked at it already. Week 3 is about Syria, weapons of mass destruction, and generally sort of modalities of maybe intervening in a setting where a government commits atrocities against its own population. And having discussed the Syria dramas, we will continue with controversial issues, namely counterterrorism and counter-piracy operations under international law. Before, in the 6th week, I will return for a discussion on investment law, slightly different in style, sort of from the sort of dramatic security-focused topics that we're addressing in the next few weeks. But again, I'll be back for a hangout in week 6 to discuss investment. And if those of you find that if you find that it doesn't quite sound as exciting as drones or terrorism, then stay with us until week 6. I think the real drama is in week 6 when we're discussing investment. Now, the bigger message is, of course, stay with us for the rest of the 6-week MOOC. It's a deliberately long MOOC. Let's talk about MOOCs that they should only be 2 or 3 weeks because the attention span would not be as long and all this. So you can disprove those assumptions, and you can prove and show that MOOCs can run over 6 weeks. And I think in this case, it's good that it's running for 6 weeks, because it will give us a critical mass of international law disputes and give you an opportunity to assess how international law functions in a range of settings, not just sort of 1 or 2, but 6 of them. And I think the mix will be, I hope will be helpful in terms of enhancing your understanding of how international law tries to strike a balance, as we said in the trailer and as we say in the title, between right and might in international relations. So do stay online. Keep fielding questions to our brilliant team of student mentors, Pia, Athene, and James. And also, if you feel that in the discussion it's only always the same people that engage, I mean, do encourage others to engage in various ways. There's still time to sign on. You can still sign on for this course, and if you feel that so far it's been okay or good fun even, then tell your neighbors and tell your cousins and tell your friends. They can still join, and they can still join in an active way. It's not that we're barring people from participating in week 3 if they haven't participated in weeks 1 and 2. And for those of you who so far listened passively mostly, I mean, this is not a problem. This is an entirely perfect way, perfectly legitimate way of participating in a MOOC. But if you feel like it, don't be discouraged. I mean, do join the debate. It'll enliven the course, and it'll make it sort of more interactive still. So many thanks so far for the first 2 weeks of good discussions. Make sure you sort of tell your friends if you've enjoyed it. Make sure to tell nobody if you've not enjoyed it. That's it from me from our second week on right versus might in international relations, our case study on Guantanamo. As I said, come back next week for the case study on Syria. It's a good course. It's a good experience for those running this course, and I hope you share some of the enthusiasm that we're bringing to this. Many thanks.